SJC-12254, Commonwealth v. Kevin A. Mauricio.
Good morning.
1 second, Mr. Zendrasky. Just give us a moment.
Thank you.
Okay, you may proceed now, please.
Good morning. May it please the court, my name is Matthew Zendrasky, and I represent the appellant, Mr. Kevin Mauricio. This appeal concerns one main issue, whether the trial court erred when it denied his motion to suppress evidence stemming from a warrantless search of his digital camera after he was arrested.
Can you explain to us how it is you have standing
Well, I
in the camera?
believe you're getting into the stolen property argument. I don't believe that the...
No, I'm getting into how it is that you have standing to pursue the claim you're pursuing. Do you have any kind of privacy interest to protect in the camera?
Well, Mr. Mauricio filed an affidavit at the...
That has no evidentiary value.
I would argue that the Commonwealth is raising this claim for the first time on appeal, that this was argued before the trial court as Mr. Mauricio's camera, that there was no evidence presented that this camera was stolen.
So are you suggesting that if its standing is not raised below, it's basically waived?
Yes.
Well, this was, I gather, this was seized pursuant to an inventory search.
Yes, Your Honor. It was, the inventory officer was searching Mr. Mauricio's backpack after he was arrested.
And it was included, I've not seen the inventory itself. Is this among the items included in the inventory?
The inventory actually was not introduced into evidence at the trial court.
But I gather there's no dispute that indeed it was done by an inventory officer and it was viewed as part of the inventory taken upon his arrest.
Yes, there's no dispute. It was in the backpack when he was arrested, and the inventory officer searched it.
So would it matter if it were an old Instamatic with 12 photos in it?
I would argue that it would, because the case is about an electronic device, a digital camera, which has a vast storage capacity, and this is what makes it similar to a cell phone. And the Riley case and the Diet case, which examines the privacy interest in the vast quantities of data that a cellular telephone can contain. And so similarly, a digital camera has a memory card and can store hundreds of photo albums, videos, and can even store any kind of information that you can store electronically could be stored on the digital camera. That the storage capacity of the electronic device is not limited by the physical size.
So you're basically saying this is essentially an extension of Riley, but Riley speaks of cell phones, and this is analogous to that part of the cell phone which contains photographs.
I am arguing that is analogous to Riley in that it's the part of the cell phone that contains photographs, and also that it's a memory card and it can store any kind of data on the camera. And so it's not just limited to photographs, it can store anything. It is an electronic device that's modern, and there's virtually no limit to what could be stored on that data.
Would this search have been okay before Riley?
Well, my argument is based off of Riley, because Riley extended the privacy interest into the electronic device.
So if this was solely an inventory search, did it extend beyond the permissible limits of an inventory search, notwithstanding Riley?
Oh, yes, it is well beyond the limits of an inventory search. An inventory search is limited to basically cataloging a prisoner's property to keep contraband out of prison, to make sure there's no drugs in the property. It's essentially a mechanical process.
Sort of a cataloging.
Yes, and specifically, sifting and reading materials are not permitted in an inventory search. And the inventory officer in this case clearly went beyond an inventory search when she looked through the camera, photos on the camera, as there was no possibility that that could hold any contraband or anything, drugs that could get into the prison system.
So you argue sufficiency of the evidence, I gather.
Yes. So, as a result of the search of the digital camera, the inventory officer, took the photos of the firearm to the detective, who then was investigating the case involving the missing firearms, and it turned out that the homeowner was also missing a Tiffany mesh ring. And so that was included as evidence in the trial against him for receiving stolen property with a value greater than $250. However, the Commonwealth did not introduce any evidence as to the value of the ring or any...
Well, with regard to the firearms, I mean, generally, with regard to sufficiency, we look at what the evidence was at trial. We don't excise evidence which we later determined should have been suppressed. That's a different question, is it not?
Can you repeat the question? I'm sorry.
If there is evidence that we determined to be unlawfully obtained, which is admitted at trial, we evaluate the sufficiency of the evidence with the evidence that was admitted at trial, lawful or not. We don't say we're going to now remove that evidence because it was unlawfully obtained and now determine sufficiency. Isn't that correct?
I did not anticipate that specific issue, so I would ask for leave to file a supplemental brief after researching it. My argument pertains solely to the ring.
Okay.
And the value of the ring.
So if I am right, which I am sometimes, but not all the time, then you'd be limited to the issue of suppression. And then the Commonwealth could determine whether it could, at a new trial, prove all of that separately.
Yes.
And if there are no further questions, do you have any further argument?
Yes, I actually want to go into a little bit about the stolen property argument, that there is no basis to find that the digital camera was stolen in the first place, because the Commonwealth failed to raise this issue at the lower court. The motion judge only found that the camera may or may not have belonged to Mr. Mauricio, but did not find that it was stolen. While he was arrested for a break-in, no one reported any missing property from the break-in.
And that was a question I had, that first break-in that basically resulted in his arrest. They identified him by virtue of the red gloves, or they described him. Well, anyway, so he and his girlfriend were arrested. But what was known to have been taken from that B&E?
There was no evidence introduced as to anything taken from that house break-in, at least at the motion to suppress hearing. So there's no evidence that anything was taken from that house break, nor is there any evidence that anyone else claimed that digital camera.
So what was in his backpack, and it was his backpack, I take it, were needles, pills, coins, jewelry. I take it the jewelry was just the ring? Was there other jewelry?
The record does not reflect.
What about electronic items? I saw some reference to 2 cameras.
Yeah, the first motion to suppress hearing, the judge found that there were 2 cameras in his backpack.
So we don't know anything at all about. We don't know anything at all about the other camera.
We do not.
Or were there other electronic items besides the 2 cameras that we know about?
I don't believe the judge made any specific findings.
Was there evidence of it at these? I mean, do we have a record as to what was introduced in evidence? Of transcripts?
Well, there were the transcripts, but they did not introduce any inventory reports.
No, but did they describe what was in the backpack?
The police officer was, or the inventory officer was kind of vague about what was in the backpacks. I have the quote that she gave. She said, the camera came in with a bunch of stolen property, and I was categorizing all the items. We had a lot of jewelry and money, a little bit of money in the camera, and I just happened to see.
So was there anyone else who testified what was in that backpack? Because I don't understand where the two cameras came from, if that wasn't something she testified to.
It was at the first motion to suppress hearing, which
So do we have the transcript from that?
you do have the transcript for the first motion.
That
hearing.
more specific about what was in the backpack?
I don't believe so, because that turned on the issue of if the officer could search the backpack in the first place. Incident to arrest.
And with respect to the receipt of stolen property charge, was that limited to the ring?
At trial, it was the ring and the firearms that were the stolen property at issue at trial.
Okay, but not the camera.
Not the camera, no.
So no one has alleged that the camera was indeed stolen property received by him
Yes.
until now.
Yes, this is the first time this is being argued.
And it was his photograph that was on this camera?
Yes, this was a photograph of him holding firearms, and that was,
So that's the camera that's alleged to be stolen?
that the Commonwealth alleges for the first time on appeal was stolen property.
Yeah.
I also want to add that there was a motion to reconsider, and at that motion to reconsider, the trial judge also found that the property in Mr. Mauricio's backpack was apparently unrelated to the break-in. So, if there are no further questions, I'll rest on my brief.
Okay, thank you. Mr. Nadeau?
Good morning. May it please the court, my name is Stephen Nadeau. I represent the Commonwealth. With me today is Assistant District Attorney Sean Gilderson. Members of the court, the Commonwealth is asking the court today to find that, or to hold that a defendant has no legitimate expectation of privacy in stolen property, and that where the police have an objectively reasonable belief that certain property is stolen, they may search that property to determine who the true owner is.
So what was the objective belief based on? That was
In this case, Your Honor, it was the observations reported to the police by the neighbor to the initial house break. He had seen the defendant fleeing from the scene of a house. He knew him not to be legitimately on the premises. He provided a description of him and his female companion to the police, who tracked him down about a block away, both of them. The officer conducted a frisk of the defendant for weapons, also checked into his bag after the defendant indicated there were some needles inside, and the officer found several electronic items. I believe Officer Collins testified at the first motion to suppress hearing that there were a variety of cords, iPads, or iPods rather, 2 cameras, jewelry, and currency. So certainly the circumstances of finding, and then if I can just step back, the defendant's brought back to the scene where he is positively identified by the neighbor as the individual he saw running from the house, and the homeowner in fact confirmed that there had been a house break at that time.
Well, let me ask you about the camera. Was it, how do we know that the camera was stolen? I
Well,
mean,
I give that background merely as the
no, you were
circumstances
answering
it's discovered.
the question, but part of your argument started with there's no reasonable expectation of privacy in stolen property, but he wasn't charged with receiving the camera, so I'm a little confused about how that applies to this case.
Sure, and this doesn't appear on the record. I would say for the court's information that the defendant was charged with a variety of offenses on another docket relative to that house break. This docket only covers the issue of the firearms that the photographs provided evidence of.
So he was charged in another complaint with receiving the
Yes.
camera as stolen
Or
property?
I'm not sure if that necessarily covered the camera itself.
The camera on which his own photograph appeared?
Yes.
That was his stolen camera?
That certainly the circumstances objectively at the time supported the belief that they were stolen.
No, I meant, was that the criminal charge? I mean, was that among the items that the police would have charged him?
That I'm not sure about which specific property. would have been covered in that
So
other case.
what's the constitutional justifications? Is it inventory search or is it search incident to arrest?
I think it would be neither to even determine whether one of those exceptions to the warrant requirement applies. The defendant must first establish that he has a legitimate expectation of privacy in the place searched. And the fact that he may have used the camera, stolen the camera, and then used it to take pictures of himself doesn't necessarily subtract from the finding that it may have been stolen. I believe the fact finding by the judge here was that it may or may not have been the defendant's camera, but certainly he implicitly found the officer's belief that it was stolen.
So as Justice Link opened it with your brother, this is a standing case in your mind?
To the extent that expectation of privacy is subsumed within standing, although that is
Yes,
one of the
yeah.
threshold requirements for the Fourth Amendment. And I would,
So are you doing this in connection, it's like not an Amendola automatic standing case?
I don't believe so.
So then he has to establish standing,
I'm sorry?
then he has to establish his standing,
Correct.
and he didn't. Is that your argument?
Yes.
Well, I mean, I'm sorry, under our case law, first he has to establish standing, then he has to also establish legitimate expectation of privacy.
Right. So given that he's charged with possessory offenses or offenses that have as an element possession, he has standing to challenge that. Right. But he must then also establish a reasonable expectation of privacy.
What do you say about the waiver argument that your brother made, that issue's waived because it wasn't raised below?
I don't believe the issue is waived. I think there is clear precedent that the Commonwealth, if the motion below is fully argued, if there is a legitimate reason apparent on the record for upholding it that's not the reason that was urged below, the court can uphold the decision on those grounds.
Well, how is that fair to the defendant if you didn't raise it below?
Well, it's fair in the sense that the defendant in any motion to suppress has the burden of establishing his reasonable expectation of privacy. And his mere statement here that it is my camera in an affidavit was not sufficient, or the judge clearly didn't credit it entirely as true. And unfortunately, this is one of those situations where there's not really any case law from our own jurisdiction, so we've urged the court to look outside. It's also not a case that the Supreme Court appears to have addressed squarely, although I do note that in Rackus versus Illinois, footnote 9 in that decision, the court there described as inexplicable lower court decisions that found defendants had a legitimate expectation of privacy in stolen motor vehicles.
But here, it was taken pursuant to an inventory search.
That was part of how the camera got to
Doesn't that
Detective
inventory
Tracy.
search suggest that it's viewed as his property, and upon his release, it'll be returned to him?
I would say not necessarily. It could have been processed as evidence of the crime that he was under arrest for.
But it wasn't. It wasn't taken and seized as evidence, incident to arrest. It was taken as an inventory search, which generally means it's his property, or at least treated as if it is his property. So
Correct. But even as the testimony below was by the detective, she believed the property was stolen.
So how far does that get you, her belief? I'm puzzled here.
Well, that's why I think it has to be objectively reasonable based on the facts and circumstances.
But because you did not raise it, there was no opportunity to test that at the hearing as to whether or not it was objectively reasonable.
Sure. But again, I think there is enough information on the record, given the very peculiar circumstances that the camera here was found in, that a reasonable conclusion was that this was stolen property.
Was there any evidence that the inventory officer had spoken to any of the investigating officers?
She didn't specifically reference a conversation. She did indicate her understanding that it was stolen, that it was connected to a breaking and entering. Certainly the implication would be that she had spoken to someone about it, and even if she didn't, it seems like the collective knowledge doctrine.
But if your argument is that, of course, this was stolen property and he was arrested for B&E, how is it not a search incident to arrest? Why did you abandon that argument?
Because I think there's language in Riley versus California that discourages the conclusion that this would have been a valid search incident to arrest. Obviously,
This has to do with rifling through a cell phone.
right, but there's language, I think it's at page 2439 of the Supreme Court reporter, where the court indicates that part of their concern is that even if you isolate the forms of data on a cell phone to one type of information, and they specifically talks about images that could be contained on a cell phone, and that rather than, you know, a picture that might be in a wallet, digital information can have thousands of images marked by time, date, possibly geographic location. So given that language seemed to bode poorly for the idea that they could have, knowing that this was, if they had known or believed this was the defendant's camera, they could have gone in.
So you hitch your wagon to a doctrine that wasn't argued below.
Well, I think the reasoning of, again, because there's no Massachusetts authority on this point, I think the court below was somewhat constrained, but his reasoning certainly seemed to reach that point when he essentially concluded it would have been impractical for the detective, the evidence officer, to inquire if this is stolen. A thief would be expected to claim it as his.
Please finish, I'm sorry.
I'm sorry, that was essentially the end of that point.
Okay, let me, so he is observed perhaps just finishing a breaking into a house.
Yes.
And then there's a description, the police find him, and he's got a backpack.
Correct.
And there's a question about needles in the backpack. But there's probable cause that there just was a B&E, right?
I'm sorry.
There's probable cause at the time of the arrest, he's arrested, probable cause that there's just been a breaking and entering, is that right?
That would certainly be the Commonwealth's argument. I don't believe the judge found at that point there was probable cause, but there was enough to bring him back to the original scene to conduct the show-up.
And after the show-up, there's probable.
Right, correct.
Okay. So why isn't there probable cause that there's something stolen in the backpack that he just came out from the B&E with?
Well, I think at that point, there is probable cause to believe that this stuff is stolen. I think if these facts came to the court on a posture not unlike that in Commonwealth versus Cromwell, the receiving stolen property case, this court would likely, based on the sufficiency of the evidence standard, uphold a conviction.
I'm not talking about the conviction. I'm going to Justice Gaziano's question about the constitutional justification. So the standing issue or the expectation of privacy issue isn't argued below, right?
Correct.
Okay. So I'm just asking you, in this situation, would the police, seeing this person coming out of the house and he's got a backpack with him, and it's a suspected B&E, have probable cause that there's stolen items in the backpack?
Yes, but I think probable cause would at that point get them into the backpack to search for evidence. I think then it's a second question whether that would get them into the images on the camera
All
itself.
right, I understand that. Okay.
So you're saying if there's a reasonable expectation of privacy in the camera, that the photographs would be treated like the photographs on a cell phone?
If this were a case where he had been stopped maybe for a drug transaction, just a camera in his pocket, no real doubt that the camera is his, he would certainly obviously have a reasonable expectation of privacy, not likely to contain fruits or instrumentalities of the crime for which he's suspected of. The police would not be able to just go into that camera.
Wouldn't it have been more prudent to just get a search warrant?
They certainly could have in this case, but again, where the objective facts before the police supports the conclusion that this is stolen, it's, as the court found below, it would be impractical, but also unnecessary because the defendant here did not have the expectation of privacy. I would direct the court's attention.
He did have an expectation of privacy. Wouldn't there be a need to do more than was done here?
I'm sorry?
If there was a reasonable, if it was his camera, and it was an inventory that was being done, and this police officer on her own decides, this is stolen, I want to find out whose it is. doesn't it sort of, at that point, switch from inventory to investigatory? And at that point, isn't there a warrant needed?
Again, if there were not evidence that it was stolen, that this were the defendant's camera, that would have established his expectation of privacy, triggering the requirements of the Fourth Amendment, to which the inventory would be an exception, but probably not to get into the images themselves.
Are you conceding this point? Are you saying if we decide that this really was what it smells like, a search incident to arrest, investigatory, are you conceding that they couldn't get into the camera absent a search warrant under Riley?
I think Riley does tend to foreclose that on these facts.
So I guess the answer to my question is yes?
Yes.
All right.
So then if this is an inventory search, what's the point of going into the camera if it's just an inventory search?
Well, as you said, to determine who the owner was.
Investigation.
So far as it goes, correct. But again, where there's no expectation of privacy, there's no Fourth Amendment violation, regardless of what the purpose of the search is.
So if somebody breaks into the T-Mobile, and then they've got a backpack and there's 10 cell phones in the backpack, Riley controls, and you can't look at anything to see whether they are T-Mobile's cell phones or the person's cell phones? I'm not sure I'm seeing Riley in this situation, is what I'm saying.
Well, if it's been stolen from a T-Mobile, there would be no expectation of privacy preventing the police.
Your position that there was probable cause that the camera was stolen. Isn't that your position?
Yes.
So I'm not sure, going back to Justice Graziano's point, what Riley has to do with this. I mean, it can't be an inventory search, as Justice Bud just said. It's not inventory if you're investigating.
I'm sorry, can you repeat?
It can't be inventory if you're investigating.
Right.
And if there's probable cause that the phones are stolen, does Riley apply? And if there's probable cause the camera is stolen, does Riley apply?
If there's probable cause that the items are stolen, I would say Riley does not apply.
All right, that's different what you told Justice Graziano, though.
I misspoke. I guess I thought.
Yeah, that was the question I asked you. I said if we think this is a search incident to arrest, and it's a search incident to the arrest for stolen property, we've got a B&E person with a backpack full of stuff, right? And they get it back. An inventory search is one camera, check, and they move on. An investigation is what's in the camera. And what we've been trying to ask you is, are you conceding that the police under Riley needed a search warrant before they could rifle through the digital camera?
That certainly seems to be, yes, that seems to be the direction Riley is pointing in.
So that's different than the answer you gave me.
I guess the distinction I'm trying to make, that I guess I'm...
If there's probable cause that the phones are stolen, or there's probable cause the camera's stolen, does Riley apply?
I'm sorry, no, Riley would not apply in that circumstance. Because Riley applies where by all indications the phone in fact belongs to him. That it is his phone. When the police are searching it incident to arrest, they must first acquire a warrant. In this situation where the evidence certainly supports the conclusion that the phone was stolen, Riley would not apply because it's technically not a search incident to arrest. It just doesn't rise to the level of a constitutional search in violation of the defendant's Fourth Amendment or Article 14 rights.
I understand. I get your point. I know it's a little
I apologize for
No, it's okay.
getting.
Okay, thank you.
Thank you.